to the NAFA webinar series, providing you with timely information and training each month on topics of interest. This is Brendan Burnett, Director, Professional Development and Education Programs. Today we are presenting Planning for the Modern Family. Back with us for a second webinar is Kristin Mackenzie, an Associate Professor at the College for Financial Planning. Kristin has over 20 years of experience in the financial services industry, both as an active financial planner and as a provider of financial education. She graduated from the University of Connecticut with a degree in economics and later received her MBA at the University of Colorado. Prior to joining the college, Kristin worked at TIAA-CREF. Kirsten Waldrop. Kirsten is an Associate Professor of Estate Planning and Taxation at the College for Financial Planning. Kirsten worked in private practice as an estate planning and administration attorney prior to joining the college. She graduated from Arizona State University with a bachelor's degree in interdisciplinary studies of business and communication and received her JD from Syracuse University College of Law. We are thrilled to have both Kristin and Kirsten with us today, and during today's webinar, our presenters will provide you with a detailed overview of retirement planning and estate planning considerations for the broad variety of non-traditional families. As non-traditional families are frequently less financially secure and are less likely to feel knowledgeable about how to reach their goals, they present a tremendous opportunity to the insurance and financial advisor. We would like today's presentation to be interactive and encourage you to type your questions on the question box on the right side of your screen at any time during the presentation. Questions will be answered throughout the webinar and during a brief Q&A session at the end. So let's begin. Kristin and Kirsten, I'll turn the discussion to you.
Okay, thank you very much, Brendan. And good afternoon, everyone. Thank you for joining us for today's presentation on rights and benefits for modern families. Kirsten and I think that this is a very timely topic, as Brendan had indicated, and we hope that you get some things out of today's webinar that you can take back to your practices. Again, my name is Kristin Mackenzie, and I'm an Associate Professor at the College for Financial Planning, and I specialize in retirement planning.
Good afternoon, I'm Kirsten Waldrop, and I'm an Associate Professor of Estate Planning at the College for Financial Planning.
Okay, well, let's go ahead and get started. Who here is part of a so-called traditional family? Probably very few of you. In fact, neither am I. Only 1/5 of American families today are considered, quote, traditional families, which is defined as two married, opposite-sex parents with one or more children under the age of 21. Traditional families have been replaced with what is often called the modern family. Modern families can include single-parent households, blended families, same-sex couple families, domestic partners, and multi-generational households, and everything in between. Studies show stark differences in the financial security of modern families as compared to traditional families. Specifically, only 51% of modern families think that they are on track to achieve their financial goals. That's a full 10 percentage points lower than their traditional family counterparts. Modern families are also more likely to suffer the loss of a main source of income. They have an increased need to declare bankruptcy, and they have difficulty saving for retirement due to current financial demands. Despite the financial strains they're facing, only 25% of these families are currently working with a financial planner. This is a big opportunity for those of you who understand how to tailor products and services to meet the needs of these new family structures. Let's go ahead and begin our discussion by looking at planning considerations for single individuals. Nearly half of all Americans today are single. The trend has become to marry later in life or not marry at all, perhaps cohabitating, living together, or parenting solo. And even if you do marry, statistics show that you may find yourself divorced or widowed later in life. Single parenthood is also becoming increasingly common, with half or more of today's children likely to spend at least part of their childhood in a single-parent family. For a number of reasons, singles may need financial planning more than any other group, but their needs are quite different from married individuals. For one, they don't have anyone to share living expenses with. They don't have a backup salary in the event they get sick or lose their job, and they only have themselves to rely on saving for retirement. Tax experts add that single adults often face steeper tax challenges. They don't often have child tax credits, spousal exemptions are not available, and they have no one to file jointly with. So they can take a pretty big tax punch during peak earning years. To mitigate these risks, singles should take action to secure their financial futures. First, as with any client, you need to set the stage for financial security by setting up an emergency fund. Many planners recommend setting aside 3 to 6 months of living expenses. Personally, I think that singles should focus on accumulating closer to 6 to 9 months of expenses. Next, get insured. Many singles think that because they're single, they don't have a need for insurance, but in fact their need is probably as big as that of a married person. So encourage your clients to purchase health insurance. This applies especially to your young clients who often think that they're invincible. Not only is it the law, but the vast majority of bankruptcies are caused by medical debt. Next, encourage your clients to purchase life insurance, at least a term policy that will see their children through high school or college and take care of final expenses. Next, income is likely your single client's most important asset, and it needs to be insured. Make sure that they read the fine print in their employer's disability policy. How does it define disability? What is the length of the benefit period? Most employer-paid disability insurance replaces only about 60% of income, leaving a gap that many individuals will really want to consider filling. Then, once you have taken steps to secure your earnings, you'll need to begin thinking about building retirement accounts, and singles will need to be especially aggressive about this. And finally, long-term care. Singles should consider purchasing long-term care insurance more than any other demographic because it will pay for the care that might otherwise be provided by a spouse or children.
Turning now to estate planning. Let's assume the parents get along but decided they don't want to be in a relationship or don't want to get married. Since the parents aren't married, the other parent will have no right to make a claim, such as a spousal elective share, against your client's estate. So, if your client wants the other parent to inherit, it needs to be in writing. For guardianship purposes, the surviving parent will most likely become the full-time guardian or parent of any minor children. However, your client can determine whether that parent has control as custodian over any assets that are bequeathed to a minor child. Also, your client will need to consider who should be appointed in all of the fiduciary roles. So this will be your personal representative, trustee, financial and medical power of attorney. And keep in mind that since the parents are not married, there is no statutory priority to serve as a fiduciary in the event of intestacy or to make medical or financial decisions on your client's behalf. Now, if a child's adopted, your client will want to be sure to update his or her estate planning documents to reference that adopted child. Most state statutes do include adopted children as children for inheritance purposes, but it's always good to specifically outline your desired beneficiaries. So let's look at the estate planning considerations to be made for single individuals with no kids. A single person doesn't need a will, right? They have no kids to leave anything to, no spouse to take care of. Someone's going to handle their affairs when they die, right? Maybe. But more than likely, not making a will is going to add to the time and expense of the estate administration. If a person does not create a will, at death, the state intestacy laws will apply to the administration of the estate. This means that the government is creating your estate plan. Now, I think it's safe to say that this is not the average person's ideal situation. Most state intestacy statutes look to the closest living bloodline to inherit assets, and if all else fails, the assets are going to end up going to the state. Now, some people might think this is easier and cheaper than going to an estate planning attorney. Well, you also have to consider that your assets will now be paying for the court to locate and appoint a person to serve as your personal representative, locate your heirs, and administer the estate pursuant to state statutes, in addition to filing all the necessary paperwork with the court. It's also going to be very important for a single person to execute a durable general power of attorney, a healthcare power of attorney, and a living will. If the individual needs help managing money or making medical decisions, there isn't a spouse or child for the institution to turn to. This means that any decisions will be delayed until a relative can be located or until a court appoints a proxy. So next we're going to look at single parenting due to divorce. First, if your client's responsible for making alimony payments to a former spouse, there are techniques to ensure that sufficient funds will be available to provide those payments, provided the money is available to that spouse up front. For example, with an irrevocable trust, the alimony payments can be made to the former spouse as beneficiary of the trust. Your client won't have to worry about making the required payments and complying with the court order in the event his or her financial circumstances change later on. The former spouse might be particularly interested in this tool also if the obligor spouse is careless with money. For tax purposes, the spouses would likely prefer a payment method such as this one, rather than the payor spouse providing the full alimony obligation in one lump sum. For alimony, keep in mind the former spouse receiving payments has to recognize those payments as income, and the payor former spouse gets to deduct those payments. Also, an irrevocable life insurance trust can be created and funded with enough assets to purchase a life or disability insurance policy on the obligor spouse's life, payable to the former spouse. This way, the former spouse is guaranteed alimony payments even in the event of the obligor spouse's death or disability. You can also use these mechanisms to secure child support payments. Second, if your client's divorcing and retirement assets have to be divided, or to secure child support or alimony payments, a qualified domestic relations order should be considered. This is commonly referred to as a QDRO or a quadro, and it's a tool to assign some or all of a qualified plan benefit to a participant's spouse, former spouse, child, or other dependent. A QDRO is a court order, so it's not a document that can just be drafted and submitted to a plan administrator. The QDRO will specify the ex-spouse and describe how the plan administrator is to distribute the benefit in one of three ways. The benefit can be distributed directly to the ex-spouse, to an IRA owned by the ex-spouse, or it can be segregated until the participant spouse reaches retirement age and then paid out periodically to the ex-spouse. Third, it's critical that you update all of your estate planning documents following a divorce. This includes your will, trust, general durable power of attorney, medical power of attorney, beneficiary designations, and any other documents that you might have. Now, you may have noticed I said following a divorce there. What if you're in the middle of a divorce? Can you update your estate documents? The rules will vary by state, but typically you may not change any dispositive provisions of a will or trust during a divorce proceeding. Legally, the spouses are still married and can't disinherit the other without getting into a little bit of legal trouble. While a divorce is pending, however, you can and probably should update your powers of attorney documents and remove your spouse as your financial and healthcare power of attorney. Then, once your divorce is finalized by the court, you can update your will or trust and remove your spouse as beneficiary. Lastly, a single-parent household may result from the death of one spouse, leaving the other spouse a widow or widower. On the death of the first spouse, the primary concern for the average person will be making sure the surviving spouse is able to continue providing for him or herself and any minor children. If the breadwinner spouse is the one that dies, will the surviving spouse be able to continue caring for the family? As you all know, life insurance could be key for this situation. Also, a big issue arising in the digital age is access to accounts. Upon a death, a lot of companies will freeze an account and will not give access to the spouse or fiduciary for an extended amount of time. Make sure your clients have access to all online accounts. So let's look at the surviving spouse. Obviously, the estate plan will need to be updated. The marital deduction is no longer available, and you'll have to determine whether the surviving spouse may need to elect the deceased spousal unused exclusion or DSUI amount. Think about who will serve as personal representative or trustee and as your financial or medical power of attorney. If there's minor children, who will serve as the guardian or custodian? And how do you leave assets to any minor children? Minor children, while they can be beneficiaries of an estate plan, they cannot gain sole access of any bequeathed assets until they've reached the age of majority. So what happens to the assets in the meantime? There are a few different options available for this situation, and which one is best is going to depend on your client's goals. For example, a custodial account or a trust can be created for that child.
Okay, let's turn now and talk a little bit about planning for blended families. I think this statistic is really interesting. It indicates that more than half of Americans today have been, are now, or eventually will be in one or more step situations during their lives. That's a significant market. A blended family, by definition, is a couple and their children from any previous relationships, as well as any children they may have together. Another word for blended family is a step family. And unlike TV's The Brady Bunch, which you probably all remember, real-life blended families often face big challenges. Perhaps the biggest sore spot is management of the family finances. This can range from whether to pay an allowance to the children to how to pay for college. Many couples in blended families struggle with maintaining their household expenses while making child support or alimony payments and saving for the future. It can be all but impossible. In fact, a recent study found that blended families average only $158,000 in savings compared to $264,000 for traditional families. Anyone in midlife or mid-career will likely be bringing financial baggage to a marriage. So before your client says, "I do," for the second or third time, they need to consider, how will the household bills be divided? Does someone have a spousal or child support obligation that will impact everyone in the new household? How will the standard of living be established? What happens if one parent has saved for their kids' college and the other hasn't? Nothing says romance like retirement planning, but it is important to know what each party is bringing into the marriage, both assets and liabilities. Another consideration is whether your clients will have joint accounts. Often separate accounts are more beneficial in second marriages. Money in a joint account is susceptible to either party's creditors regardless of who contributed the money. And joint accounts also typically have survivorship features, which could disinherit one account owner's children.
When your client remarries, it's highly likely that their estate planning goals will change. First, your client should want to protect his or her children's inheritance that may be received from a former spouse, whether by divorce decree or death. The last thing you want to have happen is to have a child's inheritance be mixed up with the assets of a new spouse. So who will preserve and manage these assets while the child's a minor, and how? There are a few mechanisms that can be used to protect a minor child's inheritance. These are going to be your custodial accounts, so UGMA or UTMA accounts, qualified tuition plan or 529 accounts. An irrevocable trust is another option that can be established to ensure that assets are available to that child later on. A testamentary trust is also a great tool, and a conservator can also be named in a parent's will. Now second, your client will likely want to prevent a former spouse from inheriting property that's bequeathed to a minor child. While this might sound a little bit out there, it does happen. Now most state statutes look at the bloodline for the lineup of who stands to inherit from someone without a will. In this case, a parent dies and leaves property to a child. The child then dies, and the next closest relative is the child's other parent, the former spouse. This is effectively a transfer of one former spouse's estate to the other former spouse, albeit indirectly. Now, the most effective tool to prevent this would be for the transferor parent to create a trust. The parent can then draft provisions in the trust document that permit distributions to the child for various purposes. If the child predeceases the other parent, the trust assets could then be distributed to the remainder beneficiaries named by that transferor parent. Now, third, your client will likely want to prevent his or her child from a prior relationship from being disinherited in the future, whether intentionally or unintentionally. There are some estate planning safeguards available to ensure that this doesn't happen. First, titling property as joint tenancy with right of survivorship can ensure a child receives that property. Keep in mind that the gift tax rules will apply if the child does not financially contribute to the property. Alternatively, your client can ensure that he or she does not own many, if any, assets as joint tenants with the new spouse, since it won't pass through the probate estate. Also, a revocable living trust or a testamentary trust are common tools, but you have to be careful to ensure the possibility of the child inheriting is not left out. For example, if a trust says, leave all of my assets to my surviving spouse for his or her life, and then the remainder to my children, there's the possibility that the child of a prior marriage may never receive any property if the spouse is not limited in what he or she is allowed to use from that trust. To ensure this doesn't happen, there are some specific provisions that can be drafted into the trust document. So first, a Q-tip trust provides that all trust income is payable to the current spouse for life, with the remainder payable to the child. This will ensure that the child will receive at least a part of the trust corpus after the death of the current spouse. A potential problem with this, though, is the timing of the distribution to the remainder beneficiary. If the surviving spouse is still relatively young, it could be many, many years before he or she dies, and the child receives any benefit from that trust property. Second, using multiple trusts, one for the child and one for the spouse, is always an option to divide a parent's estate between beneficiaries. The most important part of this plan, though, is to remember to sufficiently fund each trust, since a trust is only as valuable as the assets transferred into it. And then another option would be making lifetime gifts to any children of a prior marriage. Lifetime gifts allow a child of that prior marriage to have earlier access and control of the property, guaranteeing that they're not disinherited. No matter which method your client chooses to do, you must keep in mind that it's generally against public policy to disinherit a spouse. Many states also have spousal elective share statutes that enable a spouse to make a claim against the estate. The amount's going to vary depending on factors such as length of the marriage and children of the decedent, but typically the percentage isn't going to exceed 50% of the estate. Which brings us to our next point. Your client might wish to provide for his or her new spouse. Now, we mentioned a Q-tip trust a few minutes ago to ensure that a child does not become disinherited. But this trust also works to guarantee that the new spouse receives an interest in the assets as well. The parent or spouse may also make a specific bequest to the new spouse in the will or trust document. Specific bequests, for example, I leave my spouse 50% of my gross estate, or $30,000 outright, are paid prior to the remaining provisions included in the will or the trust. Now, because of this, it's important to make sure that you have enough assets to satisfy the specific bequests, while still leaving enough to be distributed pursuant to the remaining distribution provisions in that document. In my opinion, it's generally better to use percentages rather than dollar amounts for this very reason. But if your clients have a substantial estate, that might not be a concern for them.
Okay. Let's go ahead and shift now to talk about planning for those in domestic partnerships, civil unions, and same-sex married couples. Really, the question raised by the repeal of the Defense of Marriage Act, or DOMA, is who needs alternative planning? The answer is all unmarried couples, whether of the same or opposite sex. Even married same-sex couples still require alternative planning in some federal areas and all state areas if they live in a non-recognition state. Domestic partnerships and civil unions are actually pretty similar, but the rights and benefits are going to vary by state law. Domestic partnerships have been adopted in several states, and typically the states will have a registry for same-sex or opposite-sex couples who wish to formalize their relationship. Civil unions have been adopted in a handful of states. A civil union is a relationship that is recognized under state law and provides certain state-level benefits, similar to those of a legally married couple. Typically, civil unions are available to same-sex and opposite-sex couples, and they tend to be more inclusive as far as rights and benefits than domestic partnerships do. But again, this is really dependent on state law. With each of these domestic partnerships and civil unions, couples are recognized and provided benefits at the state level, but the relationship does not extend to the federal level. When I speak of same-sex married couples, I am not referring to persons in a domestic partnership or civil union. Same-sex married couples are individuals that have been legally married in a state that permits same-sex marriage. Same-sex married couples receive the same rights and benefits as opposite-sex married couples under state law. As we will discuss, they may or may not receive the same benefits as opposite-sex married couples at the federal level. Let's start by looking more closely at planning for same-sex married couples. I'm sure most of you are familiar with the Windsor versus U.S. case, so I won't spend a lot of time on the case itself, but as a brief refresher, it was only Section 3 of DOMA that was at issue in Windsor, not the entire statute. So what was Section 3 all about? Section 3, for federal purposes only, defined marriage as a legal union between one man and one woman as husband and wife, and the word spouse as a person of the opposite sex who is who is a husband or wife. The Windsor ruling declared that definition to be not legal on the federal level. The impact of this ruling for you as planners depends on the agency involved. So let's first look at the IRS.
Shortly after the Supreme Court's ruling in Windsor, the IRS issued Revenue Ruling 2013-17, and they adopted a general rule for federal purposes recognizing a marriage of a same-sex individual that was validly entered into, even if the married couple is domiciled in a state that does not recognize the validity of the same-sex marriage. So this created the State of Celebration Rule. Now this decision by Windsor and the IRS changed many planning areas, since same-sex married couples can now be treated the same as opposite-sex married couples for federal tax purposes. So now same-sex married couples can utilize the marital deduction, gift splitting, portability of the dissui amount. For health insurance, it no longer has to be recognized as income by a same-sex married spouse for employer-provided health insurance benefits, as it had to be for unmarried couples. They can file joint federal income tax returns, and child support payments are no longer deemed to be a gift from one same-sex married spouse to the other, as it is for unmarried couples.
Okay. The Department of Labor now follows the State of Celebration Rule as well. So same-sex married couples may receive ERISA protection and retirement benefits. Specifically, same-sex married couples may now qualify for benefits including spousal rights to plan benefits at death, of course unless they waive their rights, qualified joint survivor and pre-retirement survivor annuity options. They now have the right to do a spousal rollover from a retirement plan to their own IRA rather than only to an inherited IRA. They also have the ability to use the joint life table when calculating required minimum distributions if they have a spouse more than 10 years younger than them. And the benefit of this is that it produces a smaller required minimum distribution amount than it would under the uniform table. And finally, depending on the state, same-sex married couples may also be able to use a quadro in the event of a divorce. Perhaps the most important thing to keep in mind is that you need to name your spouse as the plan beneficiary. Sounds simple, but there are frequently situations where the spouse is not named and it becomes a larger ordeal than it really needs to be. And as a reminder, this must be done by September 30th of the year following the year of death.
The Department of Homeland Security also follows the state of celebration rule. While this type of planning might not be too common, it's good to be aware of the rules just in case you're faced with this type of situation. So, once married, a non-citizen spouse is considered a spouse and will receive the benefits of a spouse, such as shorter residence period, the ability to petition for immigrant admissibility on a family-based immigrant visa, and for a foreign same-sex fiancé to enter the U.S. for marriage.
Finally, the Department of Defense, too, follows the state of celebration rule. Active military don't have to show evidence of residence or domicile. They just need to provide a certificate of marriage, and spousal and family benefits are available to same-sex married couples. These rights include military IDs, commissary rights, health care, preference in employment for civilian jobs, and other similar military advantages.
Now, with the Department of Veterans Affairs, we're going to see a different rule come about, the state of residence rule. So here it does matter where you live for eligibility of benefits. Veterans Affairs has to follow residency because these terms are included in the actual statute that can be changed only by Congress. So the rules determining whether marriage is valid are pretty particular, so I encourage you to go to Veterans Affairs website and look through the material if you have a client that might need this type of planning. For example, they'll consider a marriage valid if the marriage was legal in the place where the veteran or the veteran's spouse lived at the time of the marriage, or the marriage was legal in the place where the veteran or the veteran's spouse lived when he or she filed a VA claim or application.
Let's talk for a minute about Social Security, which is an issue I know a lot of people have questions on. If a same-sex couple is married in a recognition state and is domiciled in a recognition state at the time of application or while the claim is pending a final determination, same-sex married couples can get spousal Social Security benefits. And then, once you're approved for benefits, you can move to any other state and continue receiving benefits. There has been expressed desire to go to the state of celebration rule, but the Social Security Administration doesn't have the power to change these statutes and really needs to wait for Congress to act.
For Medicare, Medicare is governed by Social Security, so you're going to see that same residence domicile rule apply, and they too will need a congressional act before rules are changed. So for Medicare, Part A, B, and D have been made available for same-sex married couples, and it's really Part A that's at issue here. Part A is available to individuals who have at least 40 quarters of work history. Married persons can qualify for free coverage on a spouse's record or reductions in the Part A premiums. Same-sex couples can now qualify for these if they're in a recognition state.
And finally, a word on Medicaid. The bottom line regarding recent Medicaid legislation is that same-sex couples will be considered spouses in recognition states and will not be considered spouses in non-recognition states. Since this is a joint federal and state program, the rules will be tough to change. There are advantages of being considered a spouse for Medicaid purposes. For example, spousal impoverishment provisions may allow community spouses to shelter some of the institutionalized spouse's income, so it won't have to be used for his or her care. On the flip side, though, community income might disqualify the institutional spouse from eligibility for benefits. We'll get more into Medicaid in a few minutes. let's take a look at where we stand. You can see here that all of the states in red permit the freedom to marry. The states with red lines through them have a pro-marriage ruling, but there are currently appeals pending. The states outlined in blue have banned same-sex marriage, and the states with blue lines through them are the states that have now brought this matter before the Supreme Court again. Because of this split, we are now awaiting the Supreme Court decision later this very month on whether it is unconstitutional for any state to ban same-sex marriage. So what is your role as a financial planner post-Windsor? A survey by the Insured Retirement Institute found that 46% of unmarried same-sex couples plan to marry as a result of the ruling. But where? More and more states are permitting same-sex marriage, and it may only be a matter of time until we see some uniformity. Until then, now that you are familiar with various administrative agency rules, you can assist your clients in making a practical decision about where to marry and where to live. Remember that once a couple is legally married, they are required to get divorced if they decide to split up. If clients live in a non-recognition state, where can they go? Delaware and Maryland currently allow people who are married there but no longer live there to get divorced there. And Wyoming and Arizona will divorce a same-sex married couple. You should be encouraging your clients to apply for benefits like Social Security, Medicare, and Medicaid, even if they know that they'll be denied currently. It at least starts the clock running and may allow them to receive some back benefits. Review all your estate planning documents. If your clients are now recognized as married, they can qualify for the marital deduction, portability, gift splitting. These are just a few of the things that they can qualify for that may allow them to save on gift and estate taxes. Finally, if filing jointly would have saved you money, don't forget to file for back taxes as the window is closing. You have until the later of 3 years from the date filed or 2 years from the date tax was actually paid to make an amendment. So hopefully that answers some of your questions about same-sex planning. We're going to talk for a minute now about domestic partners and civil unions. Domestic partners are entitled to some of the legal benefits of marriage, but not all. And the specifics vary by state. But most commonly, domestic partners are entitled to coverage on a family health insurance policy, the right to, the right for family leave for a sick partner, the right to bereavement leave from work, and visitation rights in hospitals and jails. Moving beyond those basic rights, let's consider employer-sponsored retirement plans. Such plans are most often covered by ERISA, which provides protection for the survivors of deceased plan participants, or should I say the married spouses of deceased plan participants. ERISA requires defined benefit and money purchase plans to provide retirement survivor annuities to married employees unless they sign a waiver. But such protection is not afforded to domestic partners. In fact, they are not guaranteed to inherit their partner's account upon death unless they are specifically named as a beneficiary. Then traditional pension plans provide survivor benefits to spouses of married employees. However, many employers are now recognizing the emergence of these new family structures and are allowing employees to name a beneficiary who is not your spouse. As we indicated, the Social Security Administration does not recognize domestic partnerships, so unmarried couples cannot collect a spousal or survivor Social Security benefit. Because a domestic partner may not be able to receive your pension and Social Security benefits are not available, additional life insurance may be warranted. One strategy is to purchase permanent life insurance and name the partner as the beneficiary. If necessary, the cash value can be used to cover long-term care expenses or for other uses.
All right, some planning opportunities. This is a small sample of areas where planning differs for domestic partners. For example, property ownership. Let's say Jill and Jane are domestic partners. Jill owns a home and decides to add Jane to the deed as a joint tenant with right of survivorship so that Jane may benefit from the home when Jill dies. Are there any gift tax consequences to this? In this example, Jane did not financially contribute to the purchase of her 50% interest in the home. Since Jill and Jane are not married, and since Jane did not purchase her interest in the property, Jill's made a gift of the 50% property interest and should file a gift tax return for this transfer. To prevent gift tax from being incurred, Jane could purchase her interest at fair market value. Further, if Jill continues to make 100% of the mortgage payments, she'll in effect be making a gift of 50% of the cost of each mortgage payment. Now, if Jill and Jane were married, no gift tax would be owed since it's a transfer between spouses and the contribution rule does not apply. For Section 121, exemption of gain on the sale of a personal residence, let's say Ben and Brandon are domestic partners and purchased a house together that they lived in for 1 year before Brandon transferred his interest to Ben to prevent his creditors from making a claim on the house. Now, 3 years later, they're looking to sell the house and are hoping to each qualify for the Section 121 exemption. If both of them qualify, they can each exclude up to $250,000 of capital gains. Now, since Ben and Brandon are not married, they each must own and use the residence as their principal residence for at least 2 of the previous 5 years before the sale. In this case, only Ben is going to qualify for the exemption, so only $250,000 of capital gains will be exempt. Now, if they had been legally married, each spouse would be treated as owning the property during the period that either spouse owned the property, and the entire $500,000 of capital gain would be excluded. So I encourage you to look a little bit more into some of these that are listed there on the slide and see how they might have an impact on planning for your clients. For estate planning purposes, you want to make sure you name a domestic partner in your will as the beneficiary and the executor, as well as your agents for your powers of attorney. A domestic partner typically will not have priority to serve unless they won't have priority to serve under state statute, because remember, those statutes look at the bloodline if you're not legally married. A couple other provisions you might look at in the will are going to be your provisions regarding abatement and tax apportionment. So abatement's going to be the situation where there's not enough probate assets to pay all the claims and expenses of the estate in addition to the bequests. So in that event, bequests will have to be reduced. So if the testator doesn't want the domestic partner's share to be reduced to pay those claims, you'll have to specifically say that in the document itself. And the same goes for tax apportionment when deciding what shares will be reduced to pay for estate taxes. Domestic partnership agreements are also a very useful tool for partners to agree on specific terms in the event their relationship should later end. They're very similar to prenuptial agreements, but are particularly important because they're legally binding contracts that can be enforced by a court. Since some states don't recognize domestic partnerships, and since domestic partners are not considered to be legally married, the regular divorce statutes aren't going to apply to domestic partners, and often there's no other statutory authority for division of property for persons in these relationships. So now, who still needs financial planning? There are so many people that still need your help with their planning. If you take a look at this chart, you'll notice that unmarried persons, including persons in a domestic partnership or civil union, don't receive any of the federal benefits that we've discussed. Married opposite-sex couples receive the same benefits as they always have, and married same-sex couples must be evaluated on a case-by-case basis. So you have to look at the rules that we just discussed to know whether they qualify. So remember that for tax, retirement, and military benefits, the state of celebration rule applies, and for Social Security, Medicare, and Medicaid, the state of residency rule applies. So knowing these rules could be crucial to your planning.
Okay, and finally today we're going to wrap up by talking a little bit about multi-generational families. In theory, it sounds simple. A parent or child needs help financially or personally, so they all move back and live under one roof, similar to this picture that we see here from the show Modern Family. But whether it's a parent or a child that's moving back in and requesting assistance, there are financial obstacles that will likely arise and require special planning. The middle-aged generation that is squeezed between the demands of their parents and their dependent children even get a special name now. They're often called the sandwich generation. According to a recent survey, 18% of the population in the United States is living within a multi-generational household. This includes young adults moving back home to their parents, or should I say the family bank. And for parents, this is very challenging because their children are returning home just when they are needing to save for retirement. But for those in the sandwich generation, helping adult children is only half the battle. As we are living longer and longer, families are becoming responsible for caring for their elderly parents, which can be a big financial obligation. So for those in the so-called sandwich generation, caring for both parent and dependent children, I encourage you to think about the financial as well as the emotional costs before saying yes to either of these obligations.
Now, for most people, there inevitably comes a time when you're no longer able to care for yourself without some level of assistance. So when a parent moves in, find out whether your parents' estate planning documents, where they are, and discuss who's appointed in each fiduciary role. Depending on their relationship, it might be most beneficial for the parent to name that child who he or she's living with in these fiduciary roles. But it's also important that your client understands that it's ultimately up to the parents as to who's appointed as fiduciary. Making your client's life easier is not by itself a reason for the parent to change his or her estate plan, no matter what your client might think. Another concern, and one that might be frequently overlooked, is gifting. Once your client gets a glimpse of his or her parents' accounts, your client might discover that the parent actually has a lot of money, so much so that it exceeds the estate tax exclusion amount. If that's the case, a gifting plan may need to be implemented to reduce the size of the parent's estate. Also, for titling of property, for tax purposes, adding a person to a bank account or on the title to a property could result in a gift, which could be subject to gift tax, unless the person who's added to the account financially contributes. So your client should be sure to inquire about these implications prior to making any property transfers or changes. Another important question to ask is there the possibility that a client's parent may need to qualify for Medicaid? As you know, the cost of healthcare is not cheap, and without long-term care insurance or a similar plan, the expense can quickly deplete a person's retirement savings. And in order to qualify for Medicaid, you have to remember that there's medical and financial eligibility tests that have to be met, and these requirements will vary state by state, so I encourage you to take a look at those in your own state. But most importantly, you've probably heard of the 5-year look-back period that Medicaid imposes for transfers of assets for less than fair market value. You'll want to make sure that none of these transfers are taking place if there's any chance that your client will have to be applying for Medicaid in the future. And another question that commonly comes up is clients tend to ask how they can prepare their assets in case they need Medicaid. And what they really mean is how can I hide those assets and still receive government benefits? Unless your client's ready to give up control of his or her property, which the clients hardly ever want to hear, they're likely to be out of luck. And trusts, unlike most people think, revocable trusts, they will not hide assets from Medicaid. Now, another aspect of multi-generational planning might be your grandchildren living in the home. This is going to bring up the generation skipping transfer tax, so you'll want to be careful and look at the transfers that your clients plan to make. If a grandparent is looking to make a transfer to a grandchild, the generation skipping transfer tax could come into play. And I think we're about at time for questions now. Brendan, do we want to switch to questions?
Yes, thank you. I just want to remind our participants that if you'd like to ask a question, You may do so by typing your question in the question box on the right side of your screen. This webinar is certainly jam-packed with information, very thorough, and we appreciate that. But if there are any questions, we'll pause a moment to allow those to be asked. One question that we always do have is whether the webinar will be available, or the recorded webinar, and the answer is yes. All of the registrants for today's webinar are going to be receiving an email within 2 business days, and that will include a link that will take you directly to the recorded webinar so you can review that. I do have one question regarding the generation skipping transfer tax, which is interesting. What is the purpose for such a statute?
What's the purpose of the tax?
Of the generation skipping transfer tax.
Well, it was originally created because people were finding a way to get around paying so much tax by a grandparent, say, passing property to a grandchild instead of that grandparent's child, which just defers the tax longer, and the government decided that they didn't like that and they want to be able to get their tax on that property at the time that it would otherwise go to the parents, so they came up with the generation skipping transfer tax to prevent those kind of transfers from occurring.
I see. It was being used as a tax avoidance.
Yes.
All right. We do have one comment. The commenter says, I just want to say thanks for putting together such an informative webinar.
You're very welcome. Thank you.
Great. And at this point, we don't have any questions. So as I said, we do have one that just popped in. So we'll go ahead and ask that. I get asked a lot where clients can go for financial planning if they don't have 100,000 plus in assets. So I'm not sure that our panelists want to take a stab at that, but question regarding going for financial planning if they don't have more than 100,000 in assets.
Well, I'm not going to name any specific organization, but I think that market of 100,000-ish investable assets is becoming better served in recent months and years. I think that there are a number of different platforms that are becoming available, which is really nice, and that includes the like robo-advisors as well as other actual human being advisors who want to serve that market and help that middle class progress in their savings.
Thank you. And we also have a comment. The comment is hiding money to qualify for Medicaid, probably responding to my earlier question on the generation skipping transfer tax.
Yeah.
All right. And the commenter also mentioned about the moral issues with that regarding the hiding the money to qualify for Medicaid. Well, in terms of moral issues, it sounds like our the legislators definitely
took care of that.
Yeah.
Great. Well, at this point, we're going to be able to let our participants go a few minutes early because we are out of questions and we're almost out of time. I want to thank both of our presenters for their fascinating and thorough presentation. Appreciate their expertise, and also want to thank our participants for participating in the webinar today. As I mentioned, today's webinar was recorded, and you may access today's recorded presentation by clicking on the web link that you'll receive by email in the next 2 business days. Thanks again, and this concludes the webinar.